There you are. The court calls case number 628-044, State of Texas versus Benny Jean Reyna. Are you Benny Jean Reyna?
Yes, sir.
Would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you, sir. You may put your hand down. Mr. Reyna, before we proceed further, I need to discuss with you several constitutional rights and protections that you have. Ms. Kayleen Rivera is my court reporter. She's preparing an official record of this proceeding, including our discussion. Number one, you have a right to remain silent. That means you don't have to make any kind of statements. You can't be required to answer questions. You cannot be forced to submit paperwork with your signature. Such paperwork, especially if it is it contains or includes an admission or confession to wrongdoing. You understand that you have a right to remain silent.
Yes, sir.
You have a right to a jury trial. That means that you and your attorney and the state's attorneys would pick from a jury pool 6 people that would hear the evidence and testimony and the materials presented and decide whether you're guilty or not guilty. You understand you have a right to a jury trial.
Yes, sir.
You also have the right to what is described as a confrontation of witnesses. Those are big words, meaning that you and your attorney would have the right to cross-examine, question, or challenge any witness who would testify if you went to trial. Do you understand you have the right to confront witnesses?
Yes, sir.
And also, there's a right called the right to appeal. After all is said and done in this proceeding and the results of it, you and your attorney would have the right to demand that a higher court review the evidence, the official record in this case, and the results to determine whatever challenge you wanted to make. That is the right to appeal, essentially. Do you understand you have that right?
Yes, sir.
Now, you and the state, the 2 different entities, the defense and the state, have the right to demand that this hearing be held in the open public courtroom. You can also give up that right, but the hearing itself is not being heard in the open public courtroom because you have the COVID pandemic preventing us from doing that at this time. Instead, we're doing it by video conference, but that requires your consent and the consent of the state. That video conference is being broadcast on YouTube. So anyone that wants to can see and hear the hearing, can see the materials and the people involved. Do you understand you have the right to demand this be done in the open public courtroom?
Yes, sir.
Now, if you decide and persist on wanting to enter a plea, part of all of these 5 different rights that I just explained to you or discussed with you briefly, all of them you're giving those up. Do you understand that?
Yes, sir.
All right, now in this proceeding, I'm going to show you various documents. Each document individually will have at the top what I refer to as identifying information. In this particular document that's being shown to you right now, the identifying information, which will be repeated on the other document, says cause numbers CC 628044, the state of Texas versus Benny Jean Reyna in county court at law number 5, Bexar County, Texas. Now, below that identifying information on the documents, you'll have the title of the document. And this particular title is the state's consent to video conference. All these different documents are going to be in bold print, all capitals. This particular document, I mentioned to you a while ago that you and the state individually have the right to have this proceeding in the open public courtroom. The state has consented to do this by video conference, and that's what that document says. Ms. Caitlin C. Morgan signed on behalf of the Bexar County District Attorney's Office. Do you see that in front of you?
Yes, sir.
All right. This next document, again, with the identifying information. Now this one is titled Discovery Acknowledgement. The very first few words in this particular document state, pursuant to Article 39.14 of the Code of Criminal Procedure. That law, essentially, the state of Texas requires prosecutors, the state's attorneys, to share with you and your attorney all of the receipts, documents, materials, evidence that is involved in this case, so that you and your attorney can make an informed and intelligent decision. This document has the signature of your attorney and the state's attorney. They both acknowledge and say to the world and to the court, this law is being obeyed. It is the state has fulfilled its obligation. You see how it's signed by the prosecutor and by your attorney?
Yes, sir.
All right. The next document is your document where you consent to video conference. We've mentioned several times that you have the right to have this in open court. This consent says, that's okay, I'm waiving that right. We're going to proceed now. And that's got your signature and the signature of your attorney. You see those?
Yes, sir.
All right, the next document is titled, again, it's got the identifying information, repeats again. This one is titled Defendants Waiver of Constitutional Rights and Court's Admonitions. Did you carefully review all this document with your attorney?
Yes, sir.
Did you understand what it says?
Yes, sir.
Do you have any questions?
Yes, sir.
All right. I want to point out to you that in the first sentence, you're telling me that you don't need me to read to you word for word the papers, the documents that accuse you of, and then the second sentence says, I know I'm accused of DWI with a blood alcohol content of 0.15 or higher. That's commonly, we refer to that as extreme intoxication. Basically, it says you were polluted, you were driving, and it weren't just DWI, you were extremely intoxicated. Then the third sentence identifies the fact that your attorney has done a significant job for you, first of all, in getting this reduced from a DWI, extreme intoxication, which is commonly called a Class A misdemeanor. It's been reduced to DWI first. It will be in this proceeding. It says that you hereby enter a plea of nolo contendere, which is no contest. You're not fighting this at all. Is that true?
Yes, sir.
All right, now the rest of this document substantially is divided into 15 separate divisions or parts. Some of them are just one sentence or a paragraph. Nonetheless, did you review all 15 portions with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Each one of those different divisions or sections is numbered. Number one talks about the range of punishment. What is the punishment you could get for this offense? In the very first, there's a stack of little boxes that are vertically set up. Next to each one, it talks about a particular range of punishment. Now, I want to show you something that your attorney has done for you. DWI first is punishable from $0 to $2,000 fine and jail from 72 hours to 180 days in jail. Look down to the fourth box from the bottom. It says Class A. The DWI extreme intoxication, the punishment is from $0 to $4,000 and jail from 0 days to 1 year. Do you see and understand the distinction?
Yes, sir.
All right. Now, I want you to read number 2 for me out loud.
I understand I have a right to a jury trial, a right to cross-examination of witnesses, and a right to remain silent. I freely and voluntarily waive and give up those rights.
Do you know that that's what you're doing?
Yes, sir.
That is a true statement.
Yes, sir.
Number three, it talks about mental health. Have you ever had any mental health problems or issues?
Yes, sir.
Have you ever been given or taken mental health medications of any kind?
Yes, sir.
All right. Number four talks to you about your plea of nolo contendere. The bottom line is, it says, first of all, I need you to understand that a nolo contendere in this court is taken as a guilty plea, and it is sufficient for me to convict you outright. Do you understand that?
Yes, sir.
It also, number four, says that you're pleading nolo contendere after you've reviewed all the information available to you, the evidence, and the advice of your attorney. Is that true?
Yes, sir.
All right. Have you ever in any way been involved with a procedure called a sex offender registration program?
No, sir.
All right. Number six, I would point out to you the importance of your knowing that the deal you made with the state is not binding on me. As the judge, I have the authority and the responsibility to accept or reject your deal. This cannot happen in any way if I don't accept or reject your deal. There's two parts of that that are important. First of all, if I reject your deal outright, say, no, Mr. Reyna, this is not a deal that I'm willing to take. Or if I give you a punishment that is within the proper range, but that punishment is heavier than what you agreed to, then in both those cases, and either one, the law would allow you to start all over again, and you would not, what you said or signed up till now would not be used against you. Is that clear?
Yes, sir.
Now, I will discuss with you momentarily deferred adjudication. Mr. Reyna, where were you born, sir?
San Antonio, Texas.
All right. That means you are a U.S. citizen, and it's so noted in this official record and on the papers of this case. The rest of these documents, some apply, some don't. But you're telling me under oath that you have reviewed all 15 numbered portions.
Yes, sir.
All right. Number 15, I want you to take note. It says that you are giving up, you're waiving the right to insist that I order a needs and risks assessment. You understand that that's, you're giving that right up?
Yes, sir.
Okay. And you did review this and signed it. Is that correct?
Yes, sir.
All right. Now, there's this document, next one that you're being shown, again, repeats the identifying information for the document. And then the title is Trial Court Certification of Defendant's Right of Appeal. That's my certification to you. This talks about the right of appeal. I've mentioned it a couple of times already. There are a stack of vertical boxes. There's a vertical stack of little boxes, and next to each one is a statement or description of right of appeal. The fifth box, 1, 2, 3, 4, 5, it says, this is myself talking, certifying. It says, this is a plea bargain case and the defendant has no right of appeal. Do you see and understand that?
Yes, sir.
I will be signing, I'll be marking that and signing it. And you have signed, and so has your attorney, indicating that you understand what that means.
Yes, sir.
All right. This next document is a application for deferred adjudication. It's a specialized kind of probation. What it says, let me reword that. Did you review this application carefully?
Yes, sir.
Do you know and understand what you're telling me under oath by signing this document?
Yes, sir.
Okay. It is important that, among other things, you know this. You have made an agreement for deferred adjudication. That agreement means, first of all, although you're going to plead nolo contendere, you're pleading guilty to this court. And that is sufficient for me to convict you. I will honor the agreement that your attorney has made for you. I will not find you guilty. Instead, essentially, the word is deferred, but you can also think of it as postponed. If you live up to 100% of the conditions of supervision, and I want you to listen very carefully, I'm repeating this. If you live up to 100% of the conditions of supervision, then the case gets closed and you're not even convicted of DWI misdemeanor B or DWI first. I'm sure you can understand the importance of that.
Yes, sir.
The other side of it is, if you screw up and you fail or refuse to live up to the conditions 100%, then the state can ask me to give you official notice and have a hearing at which, depending on the evidence and what's presented to the court, it is possible that you would be convicted, a final and forever conviction. The only difference being, unless you were a real good pal of the governor and he pardoned you. I don't think you can expect that. So, very clearly, you could receive a final conviction if you don't live up to all the conditions. And by the way, those conditions will be read to you by probation personnel. You will sign them and you will have a copy in your hands. Is that clear?
Yes, sir.
And if you were to go through the misfortune of being convicted after all of this, then you'd be looking at 100% of the condition, 100% of the range of punishment. A fine from $0 to $2,000 and jail from 0 days to 180 days. You understand that?
Yes, sir.
All right. Now, what we're seeing here is a personnel data sheet. That is your personal information. It's got your name. It's got your address, telephone number. It doesn't show employment. Are you working or not?
Well, I'm a trim carpenter, so I haven't worked in a bit.
I'm sorry, say that again slowly.
I'm in construction. I just haven't worked in a while.
Okay. What is your total income on a normal basis? Let's say monthly.
About 5,000, I guess.
A month or a year?
Yeah, no, a month. I'm sorry.
Okay. All right. And you can or you do work full time?
Yes, I'm capable of working. Yes.
All right. Now, you didn't put that in there. I need you to complete that information in there. Is that understood?
Yes, sir.
And you have 3 references who will always be able to contact you. I need those put in there. Is that understood?
Yes, sir.
All right. Now, you have 4 dependents. Who are we talking about? You have children? Give me their ages.
14, 8, and 5. And then my wife.
Okay. How old is the oldest?
14, sir.
14?
Yes, sir.
Okay. Okay. Did you serve in the military? He says no. Okay. And what kind of vehicle do you have?
I have a 06 Land Rover.
All right. Very good. All right. Now we're going to load in what's called the plea agreement. This is the deal that you and your attorney have made with the prosecutor, Ms. Morgan. Okay. Now, the plea agreement, that one has a bit of identifying information. It just doesn't have the county court law number 5, but otherwise a repetition of the plea of the identifying information. The first 2 boxes will be officially marked. The first one, guess what it talks about? Again, the right to remain silent, critical right. Then the second box, as I have said for the record, identifies you as a U.S. citizen. The next section of this plea agreement is titled Defendants Acknowledgements. There are 5 small boxes stacked up vertically, and next to each one is a declaration, a statement about your different rights and protections that have been discussed and explained to you. Is that accurate, that you have checked off those with your attorney, and it is true and accurate that you understand those?
Yes, sir.
All right. Now, you were originally charged with DWI with a blood alcohol content of 0.15 or higher, extreme intoxication. The state has a motion. Ms. Morgan.
Your Honor, the state moves to waive the extreme intoxication enhancement, and the state also moves to proceed on a DWI first.
Very good. Any objections, Mr. Kelly?
No, Your Honor.
Any objections, Mr. Kelly?
No, Your Honor.
I'm just doing that to razz you a little bit since your name is Kelly.
I thought I was
All right.
first for a second.
I know. I'm just I have a little fun when I'm doing this. All right. The final box there says motions granted, motion or motion. This motion is granted, sir. You're officially charged with DWI first. The DWI extreme intoxication is waived and abandoned. So, to the official charge of DWI first, what is your plea, sir?
No contest.
You have three choices: guilty, not guilty, or nolo contendere.
Yes, sir. No contest. No contender.
All right. Very good. I accept your plea of nolo contendere. I find that there's sufficient evidence to find you guilty, but I do not find you guilty. I am honoring the decision and the bargain that you made with the state of granting you deferred adjudication. Before I do that, there's a check mark above, right above the word general conditions of community supervision. It says you are to appear, I order you to appear within 7 days in the offices of County Court at Law Number 5. You are to have them administer or apply your thumbprint to the documents that require that. There's a legal law that requires that your thumbprints be on there. Is that understood?
Yes, sir.
You're hereby granted deferred adjudication for 1 year. You will not apply for early termination of community supervision. You are fined $500 plus court costs, but it'll have a $250 probation of that fine, meaning that if you live up to 100% of the conditions of supervision, then you will pay $250, not $500. We're trying to encourage you to do what you should. Is that understood?
Yes, sir.
You will perform 48 hours of community service restitution. You will, in good faith, enroll in and complete the DWI education program, DWI victim impact panel. You will submit to a TAP evaluation and follow the recommendations. For 6 months, you're to have the ignition interlock monitor device on your vehicle. During those 6 months, you're not to drive any other vehicle other than the vehicle that you have with that monitor. Is that clear?
Yes, sir.
All right. Also, during the entire period of the deferred adjudication, sir, you're not to have any alcohol, not one drop. I don't care if it's birthday, Christmas, New Year's, whatever. No alcohol. Is that clear?
Yes, sir.
All right. You said you got 3 little ones that you have to support besides your wife. She's a homemaker?
Yes, sir.
All right. Then I'm going to set your supervisory fee at $34 a month. Any questions, Mr. Reyna?
Just those classes, can I do those online?
You'll have to discuss that with probation people. There is a lady that will talk to you before you leave for today. Her name is Maricela Luna.
Okay.
They will be placed in what's called breakout room. She will set you up give you the information you need and set you up. As I remember that I reminded you earlier that the probation requirements, the conditions are all going to be read to you. You will wind up signing them and you'll have a copy in your hands. That includes when, what, where, and why. Okay?
Thank you.
Any other questions, sir?
That's it, sir.
Mr. Kelly,
Yes, Your Honor.
any questions on the part of the defense attorney?
No, Your Honor.
Thank you. Ms. Morgan, any questions, ma'am?
Nothing from the state, Your Honor.
Very good.